Hi, this is Tim from thewhistleblower.com. When discussing the opioid crisis, the question often comes up, are the drug manufacturers liable for the crisis? Why? How? Here's a high-level look at just some of the laws that apply. An important caveat, drug manufacturers are not liable for the opioid crisis just because they make opioids. But if they engaged in improper illegal conduct in how they sold the drugs, they can, and in my view, should be held responsible. There are 4 key federal laws at issue: the Controlled Substances Act, Food, Drug, and Cosmetics Act, Anti-Kickback Statute, and the False Claims Act. These aren't the only laws, just key federal ones. Many state laws could also come into play. The Controlled Substances Act sets the overall framework for the manufacture, sale, and security of drugs like opioids. It imposes on manufacturers a duty to take steps to prevent theft and diversion. So manufacturers can't just ship tons and tons of pills to small communities or pharmacies that could not reasonably legally use that many pills. They have a legal duty to ask questions and to take steps to prevent overuse and abuse of opioids. The Food, Drug, and Cosmetics Act governs drug labeling. Basically, you can't sell a drug unless the packaging is approved by the FDA and accurately describes the proper use of the drug, including health and safety risks. So if a manufacturer lied to the FDA to get the drug's labeling approved, or if it sells the drug using false claims about risks or effectiveness, like lying about how addictive a drug is, that could render the drug misbranded and thus illegal to sell. The anti-kickback statute makes it a crime to pay a bribe to get a physician or other healthcare provider to prescribe or even recommend a prescription drug for patients covered by Medicare, Medicaid, and other government-funded healthcare programs. There are tons of reports of drug manufacturers and others paying doctors bribes in the form of bogus speaking fees, sham research studies, all flavors of debauchery and dinners, and sometimes figuratively just big piles of cash to get them to write prescriptions for opioids. If a manufacturer paid kickbacks to get doctors to prescribe their drugs, that's illegal. The False Claims Act makes it illegal to submit a false or fraudulent claim to the government. Claims for opioids could be false for a variety of reasons. For example, were the pills medically necessary to treat that patient for a specific injury or disease? Did the patient really take the drugs? Did they need as many as they were prescribed? If a prescription was not medically necessary, then the claim for payment is false. If a doctor got a kickback to write the prescription, that makes the claim false. If the marketing material used to convince the doctor to write the prescription was misleading, that could make the claim false. Manufacturers will probably argue, we didn't submit any claims. How could we violate the False Claims Act? Also a violation to cause someone else to submit a false claim or to conspire with someone else to do it. Notably, of all these laws, the False Claims Act is one where private citizens can take steps to hold the manufacturers accountable. The False Claims Act allows whistleblowers who know about a fraudulent scheme involving opioids, especially a whistleblower with insider, non-public information, to file a case in federal court, help the government hold the fraudsters accountable, and get a share of any money the company has made to repay. So this has just been a quick overview of some of the key federal laws about drug manufacturers' legal duties with respect to the overuse and abuse of opioids. If you have questions or want more information, feel free to reach out to me at tim@thewhistleblower.com, on Twitter at Tim P. McCormick, or at 207-747-7639.